live.
All right, welcome back to the House Judiciary Committee this Wednesday morning, April 1st, and we're turning now to S203. And over to you, Eric, to give us a walkthrough. And then we have one witness this morning and then one witness this afternoon on that. I don't know that we'll need more witnesses. I've reached out to Judge Zone. He does not need to testify on this one. So this could be short and sweet, we hope. Over to you.
Yes, good morning. Eric Fitzpatrick with the Office of Legislative Counsel, here to do the walkthrough for the committee of S203, which is an act relating to penalties for second or subsequent violations of operating a motor vehicle under the influence of alcohol or drugs. So this is a statute, a bill that involves DUI generally, but it's I don't want to say a simple issue because that always ends up being a problem, but I'll say it's a discrete issue. It's a very discrete issue, right? Related to DUI and specifically to multiple offenses, penalties for subsequent offenses. So the way the penalty system works right now for DUI, if you look at page 1, lines 8 through 10, you'll see what's the penalty for a first offense. It's right there. It's a 2-year misdemeanor, $750 fine. That's not changed by the bill. So, but that's what the penalty is now for a DUI first. And the structure of multiple offenses generally is that if you get an offense after that first one, a second offense, a third offense, a subsequent, the penalties go up. So the penalties become more significant if you have a prior DUI, in other words. So that structure is existing law, and this proposes a clarification to that structure, because not every subsequent offense will necessarily count as far as establishing whether you've had a prior DUI conviction. And the reason for that is because the law has what you could think of as a fresh start provision, or some could think of it as a safe harbor. However you want to think of it, the idea is that if you go a long enough time, if you have a DUI, and if you go a long enough period of time before you get a second one, well, then the first one doesn't count against you. The second one will still count as a first if you've gone a certain period of time without getting another one. And the period of time under existing law is 20 years. So if you go 20 years and after that first one and you never got another one in the intervening time, well, then you get another one, well, that still counts as a first. Does that make sense for that structure?
Yeah. So
the key point is, and that's what's being addressed with this language in S203, is how do you count that intervening 20 years? Under existing law, the way it's counted is the 20 years starts with your conviction for the first one, right? And then if you get convicted again, that would be your second. So if you haven't gotten or I should say, if you have another conviction that's happened during that period, then your second one would count as a second. The issue that has come up in practice, and you'll hear more from your witnesses about this, is that because someone might get charged with a second offense, and because of the length of time that it can take for a case to wind its way through the court system maybe perhaps there's a trial that could be subject to a trial. It could end up being significantly longer than 20 years before the person would actually get convicted of the second. So in that case, the person would have, say, just to pick a number, have a prior conviction that had actually been 21 years before the previous conviction. But in that case, because of the language of the statute, convicted of violating, who's been convicted of a violation within the previous 20 years, that person would still get a subsequent. See, that would still count as a second offense, even though it was 21 years after the conviction for the first one. So
can you walk that through one more time?
Yeah. So let's say person gets convicted.
Can you do 2000 and
yeah, right. Pick the easiest numbers.
Yeah,
right. So the person convicted, again, pick a number we're all familiar with, July 1st, let's say, July 1st, 2000, they convicted of DUI. And then on, say, July 1st, 2020.
How about July first, 2019?
Hmm.
What happens if it's July 1st, 2019, then it's not convicted, but he violates the section?
Well, there's no answer to that under the current law, because the current law depends on the conviction, not on when you got stopped by, not when you got committed the offense.
So the conviction doesn't happen until 2021, even
Right.
though the
July
violation
2nd.
was in 2019.
Right.
Isn't that the situation this is going after?
Yeah, that kind of situation. Exactly.
So-
right. That's what I was trying to say, but maybe I didn't say it.
Yeah, well, no, I think it's, yeah. So the way that actually would happen in practice is that in 2019, July 1st, 2019, they would charge that person with a DUI too. Because at the time, looking at they're like, okay, they got a DUI in 2000, that was less than 20 years ago.
Mhm.
But then it just takes so long that they actually went to trial, they would have to be convicted of DUI 1.
Correct.
Wow. That's fascinating.
So this fixes that.
Exactly. So that the idea here is that, as you were just saying, that what they're charged with the DUI second, because the offense, in the sense of the law enforcement officer pulled them over and their breath tested them and everything, if that all happened on July 1st, 2019, then that would be the operative date. So that, because you see the language is proposed, instead of on line 11, instead of person convicted of violating, a person who violates this title. And the violation happens right then, as opposed to the conviction. So that's when the outside end of the 20-year clock is the violation. So they could, if they got violated if they were violated up to say June 30th, 2020, in our hypothetical, it would still count as a second. But if it were July 2nd, I'm not sure how July 1st works, so I'm going to skip over that. Let's say, let's leave that up to the courts. But if it's July 2nd, well then, it's first. That's the idea.
Yeah, so there's a question with this because there's often plea downs.
Mhm.
Correct. So you're charged with a DUI, that 19 years or whatever it is, but then it pleads down to negligent operation or something like that. You still can't be held for a DUI, right? It's whatever.
Correct.
Yeah,
That's right.
It's whatever
That's
the resolution is.
right.
that
The
you're gonna be
ultimate
held for.
offense.
Yeah.
Well, that wouldn't count as a second.
Yeah.
I have a question, but it might be for a practitioner. Are we gonna hear from?
Yes, he should be here in 2 minutes.
Maybe I'll ask Ian someday.
We can ask.
It's more of a curiosity about like changing charges once a date, if you've ever had to like change a charge because the date passes. Anyway.
I mean, I bet what would happen is that a wily defense attorney would not
Let it roll.
let it roll. It goes to trial maybe because that's why it's delayed so long. Like what DUI 2 takes over 2 years or something to actually, and so eventually there's trial, and then actually at sentencing, or maybe with the jury instruction, they're like, well, actually it's been more than 20 years.
Yeah.
Interesting.
So did you want to walk through the third and fourth as well, or?
Actually, there is something I have to mention there. But generally speaking, so the same concept applies for third and fourth offenses as well, right? So you count. So again, because the penalties are stepped up with each subsequent offense. So third offense starts in the bottom of page 1, goes over onto page 2. Same thing here. See, again, if you get a third offense and then you have a previous at least one conviction within the last 20 years, line 2, page 2, preceding the date of the third violation. So again, it's not the third conviction, it's the third violation. That's your operative time that you counted on. Same thing, subsection E, further down page 2, this is your fourth or subsequent offense. So in that situation, again, it's if you violate DUI and you've got been convicted 3 or more times, and with at least one of those convictions happening 20 years preceding the date of the fourth violation, that's similar to what we're talking about. So it's the most recent violation, not the most recent conviction, that is the operative time period. However, there on line 16, page 2. And this is something that Hillary caught, because it sort of gives me a little segue to let you know that DUI is one of those topics that I've been covering so far this year. It's actually was in Ben's portfolio and will be in Hillary's portfolio going forward. She couldn't be here this morning because she's in the Senate Judiciary. And when we were talking about this, because we were talking about that as this moves forward in the House, you may see her in here on this bill. And she pointed out a correction that might need to be made, which is that the subsection E that we're talking about there on page 2 has to do with fourth or subsequent offenses. So on line 16, it's not necessarily a fourth offense as the most recent one that's preceding that date. So you might want to add, I would suggest that you do add the 2 words or subsequent after the word fourth, so that the most recent conviction has to have been within the 20 years preceding the date of the fourth or subsequent violation. Because it may have been that by that point, they got to a fifth, and you count back 20 years from the date of that one. You're not counting back from the fourth. Does that make sense?
Yeah.
Hopefully people aren't getting up high.
I know. I got it. But great.
That's happened. Any other questions for Eric? Thank you very much, Eric. And
Thank you.
Dennis, you got here just in time. Perfect timing. So we started a little bit early.
Yeah, I noticed that. I had every roadblock in the way to get here on time. Headed down Caroline and Essex, and then one point of entry was a new one for me. So,
Yes.
yeah, it's like loading dock without an arrow on that end. There's no arrow to show you. Figured it out. Yeah. Put on a detective hat and walk out back. Figured loading docks are usually in the back.
Okay, yeah, go ahead and identify yourself and proceed with the question.
My name is Dennis Wigmans, Wygmans. I am what's called a traffic safety resource prosecutor. I work for the Department of State's Attorneys and Sheriffs. Insofar as our support for the amendment, we have 2 decisions that are floating around the state right now that oppose each other as far as interpreting this statute is concerned. One decision is reading it very strictly, and that it says conviction right up front. And so that court's decision is basically that we can't count it as a DUI 3, for example, until the person is actually convicted of that DUI 3. And so we run into a counting problem. It would be the only statutory area in our criminal law where our statutes of limitations wouldn't apply once the prosecution starts. And what I mean by that is that statutes of limitations toll once a prosecution commences. And so, for example, down in Bennington County right now, there's a fellow who was picked up on a warrant a couple of weeks ago for DUI 2. That case is 9 years old, but because he absconded, it can only be prosecuted as a DUI 1. Because his subsequent 9 years is added to the time frame, and so he's beyond that 20-year window in that particular court's interpretation. The opposing interpretation is that the 20-year look back looks at the date of the offense as opposed to the date of the new conviction. So we have an unequal application of the law statewide. I recall some of the conversation that was ongoing back when the 20-year look back was put into place. And part of the conversation was trying not to end up in that same window for those who have practiced DUI law for any period of time. We'll recall the savings clause that we had that was enacted in 1991, which was then repealed in 1999. During that 8 years, there was a lot of litigation, and there was a lot of litigation in 2000. 3 cases made it to the Supreme Court on how to interpret that, so-called savings clause. And so it's our position that the legislative intent has been consistent with the way that all the courts have read this statute since 2019, since the 20-year look back was added up until this new decision in 2025 that you have to use the conviction date as the controlling date as opposed to the offense date. The concern is really, it gives great incentive for those who might be facing that DUI 5 to leave the jurisdiction, to flee prosecution, knowing that if they were to do so, we're applying that other court's interpretation, they could avoid the DUI 5 altogether if they stay away long enough.
What's the case?
In Bennington, I don't have
The court case, the Supreme Court case from 2025.
Oh, there's no case. It was repealed by the legislature when it was 20. Oh, the case in and it's a Windham County case. I'd have to get that to you. I can send that to you all if you're interested in seeing that interpretation. I know that the state's attorney's argument in it was that in the rules of statutory construction, it's not supposed to end up in what's considered an absurd result. And so the state's attorney was arguing that it would be an absurd result to, in just DUI subsequent offenses, hand the keys to the car, if you will, to the defendant to flee the jurisdiction to avoid prosecution. Whereas the other interpretation, that was a Orleans County case, and I can get you both cases so you can see that interpretation was that it would be an absurd result to, construct that the legislative intent was to have that, be the control date. And I saw it as presenting other issues like probable cause. How do we have probable cause to charge a DUI 3 if we can't prove that those two other convictions are at play? Essentially, we'd be forced to amend it in every case, which I think if you're just reading it strictly, our Supreme Court may agree that it would also forego any types of depositions that might be present in a felony case, for example, because now we have to treat it each one as if it were a DUI 1.
So, and you're confident that by saying the date of the violation, that's going to be understood?
So I think that in our initial draft, if you will, we were saying date of offense to make it very clear. The problem with date of violation is that there's been some drafting. If you look at the expungement statute, for example, the expungement statute appears to treat violation and conviction interchangeably. And so our concern would be that if we use violation versus conviction, that because there's been a conflated use, if you will, we're maybe going to run into some courts that say, well, I have no idea what violation means.
So,
but if we apply,
why did it end up being violation? Where did that change come from?
In as far as the Title 13 expungement statute?
Well, no. In here, you're saying that the initial.
Oh, that change was suggested by counsel, Ledge counsel.
Okay.
Yeah. Our concern, is the obvious one that we would like to make it really perfectly clear what we're talking about here. And because of different uses, strictly speaking, Title 23 has a definition of what a conviction means. And that we talked about last session, and that is a pretty broad definition to include all adjudications.
Okay, Karen, then Ian.
Yeah. Now I just blanked on my question for this. So go ahead.
Yeah, I think this is probably more of a question to the conversation that happened with the 20-year look back originally. I feel like it would make more sense if we were using the same for both the look back and the current thing. So violation, conviction. But now we've got what we're trying to really put into statute here is conviction, violation. Was there discussion back with the original 20-year look back why not to do the violation date for the initial conviction, so that, for example, someone who really litigated that initial DUI, their 20-year look back is now maybe 2 years sooner because it took that long to get convicted of the DUI.
So I wasn't a part of that. I was a mere state's attorney then, as opposed to a traffic safety resource prosecutor. And I wasn't a part of that, those hearings. I just remember the conversations that occurred. One was really looking at what's fair and what do we see as far as recidivism is concerned and so on. And it was settled upon 20 years because that seemed like a good window that included most repeat offenders, but excluded people that maybe got one when they were in college or something like that.
But I don't mean the 20 years. I just meant,
Oh, the use of that word? Yeah, I couldn't tell you that.
and yeah, why not have it be the conviction date of the original DUI and not the conviction date of the original DUI for the timing?
In the violation of the original one?
Oh, I'm sorry, the violation date of the original DUI and
So-
the conviction date. If we're now looking at, we're trying to really clarify.
Now I comprehend what you're asking. So I think in the sense of fairness, that makes the most sense, right? Because then everybody's treated exactly the same. Everybody has that same 20-year period. No matter how hard you litigate your case, you're still looking at the same time frame.
Yeah.
The problem with that is that it will cost DMV great expense and work to update all of their systems to reflect that. So if you were to impose like a more fair 20-year look back that everybody who all their violation dates are what count, then you'd want to do it prospectively and not retroactively. Does that make sense?
Yeah. So it's an ability to do this. They don't capture the violation date, or they haven't in the past.
Correct. They've always counted the conviction date.
And that's
And
what you look at to determine the 20 years.
right. So we look at the current, when I was charging them, we looked at the current offense date, and then we looked at the previous conviction dates. Depending upon what court you're in now, you're going to look at either the current offense date or hope that it resolves soon. But yeah, historically, we haven't looked at violation to violation, which I think in all fairness makes the most sense, because essentially somebody who's being active in their own defense and may litigate it further is being punished for doing so, because their 20-year look back will be a shorter distance in time than someone who pleads at arraignment if they committed the offense on the same day.
What is the DMV record that you're referring to? I guess my thought would be, you look back, you see the DUI conviction, you see the docket number, then you look up that docket, you see what date of
Right.
date the violation was, and you could run it from then. I guess what's the DMV record?
But then they'd have to go and correct all of their historical records to ensure that they were within statute. Because their historical records don't keep track of those violation dates, so they'd have to do all of the legal research in every single case to determine what the violation date was and then apply that.
What would keep us from doing it prospectively?
Prospectively, they'd have to probably change their software program, but beyond that, it's more doable. But you'd have to ask, DMV counsel about that more so than myself.
Mitchell.
Well, I know Karen had a question first. Mine's about this specifically. Is that okay? Just so that I understand. But we are changing, the bill proposes to change it to violation date for subsequent offenses. How is that? Just trying to get my head around it. That's not an issue with the DMV.
Yeah, I can explain, because the DMV is going to be looking at the convictions, the previous convictions, right? And then this new one will count towards maybe a future case. But this amendment is really limited to trial. When does the trial date occur, and what penalty can be applied based on the circumstances? It doesn't really implicate DMV's record keeping, because it's consistent with how they're keeping records right now, because they only keep track of when was that previous conviction.
Right, okay. Oh, that's interesting. So it seems like the same tool could be used to look back. Why are we using the DMV as the look back for a second?
So it's also interesting to look at, they keep essentially two sets of records. One for our DUI civil cases. Those would be largely tied to violation dates, because once you get a second or subsequent, then you're going to be, 11th day, you're going to be suspended, right, from the date of your offense. However, DUI ones is the bulk of our DUIs, and those are all conviction date, not violation date.
So there's really not necessarily a record, you'd have to go to like police records or something, or some other record for the violation date.
Right, for court records, probably would be the most accurate.
Yeah, if it's still relevant. I don't see that we have judiciary coming in on this, or can we get them into?
I reached out to Judge Zoni, he didn't feel a need.
Okay.
The,
It seems like it would be good to make sure we get their understanding of like the violate part versus the offense, or
we can ask, yep.
maybe not. There's a
So,
question though about how it's interpreted.
right. We'll also ask legislative council why they went with violation instead of offense.
Right now.
Sure, why not?
Because violation is the word that's used in statute. So you look elsewhere in the statute and existing law. The word being struck out, convicted of violating, line 12, convicted of another violation. Line 21, have been convicted 2 times of violation, so went with the consistent language in the statute. And for a little bit more background, this is the first time I've heard the offense issue when that language was run by the Wyndham County State's Attorney. And he testified downstairs, they said this was fine.
I think it will most likely clarify. I'm just, I'm a, belt and suspenders guy.
Right, so as far as, doing more, like going to the violation, that sounds like that, well, no, but it also is sounding like it's, there's something that is hopefully a quick fix for what is a problem, is that's opening up a whole bunch of new issues that we have to deal with in DMV and all that.
And I can't speak on their behalf.
Right, I mean, I would suggest that this is improving the situation by clarifying that ambiguity, and that's the way it's been working anyway. It's like, and it is 20 years, it's 18 years.
The bill could be introduced at another time.
Yeah, I would really caution against opening this up that much.
It would be it was represented to me that it would be a great expense to DMV to go back to a violation to violation.
So, in any event, other questions for Dennis? So we have Matt Valerio coming in at 2:30. That's our only other witness today, unless Judge Zone decides that behalf of probate judges that he wants to weigh in on the bill that we looked at this morning, S-179. So it'll be a short afternoon.